I'm very glad to be here. The debate over immigration has, in recent years, since I've been covering it, come substantially unmoored from practical discussion of a practical problem. And so the engagement of scholars and researchers, I think, is more important than ever now on this particular debate to be constantly working to try and bring it back down to earth and back down to a discussion of a practical problem that we're experiencing in the United States. My job as a journalist is to inform primarily, and so that's what I'm going to try and do tonight a little bit. We were asked for this panel to consider the impact of current immigration policies on families. The initiative that is having the most immediate and extensive impact on immigrant families at the moment that I know of is a law adopted in June in the state of Alabama, HB 56. The Justice Department filed a federal suit to persuade an Alabama judge to stop the law from taking effect on constitutional grounds. But in a ruling in late September, Judge Sharon Lovelace Blackburn surprised overconfident Justice Department officials by allowing most of the provisions they had disputed to go into effect. The Alabama law bears scrutiny here because it is different and more sweeping than state laws that went before it, most notably in Arizona. Perhaps even more than Arizona's statute, Alabama HB 56 represents, in my view, a turning point in the confrontation between the states and the federal government over immigration enforcement. Eroding the lives of unauthorized immigrants and their families in Alabama is an explicit goal of this law. The Alabama statute, for example, has a significantly broader impact than SB 1070 in Arizona, the mother of all state immigration laws. For one thing, given how the legend of the Arizona law has spread across the land, how it engendered a Latino boycott, but also won fierce support in Arizona, allowing Republican Jan Brewer to rise from behind to win the governor's seat. Given all these things, it is easy to forget that the most disputed clauses of SB 1070 never have taken effect. They were stayed by preliminary injunction by the federal courts. But aside from that, I want to detail several points of Alabama's law that go beyond crackdown laws passed in Arizona and Georgia and Utah and Indiana, major portions of which have all been stayed by the courts. HB 56, Section 12A, is the by now familiar provision that requires a law enforcement officer to make, and I quote, a reasonable attempt when practicable, I was going to say that in Spanish, practicable, cuando practicable, to determine the immigration status of anyone stopped when, open quote, reasonable suspicion exists, close quote, that the person is an illegal alien. Stayed by the courts elsewhere, this provision was allowed to go through by the Alabama judge. In addition, Section 10 creates a criminal misdemeanor for, open quote, willful failure to carry an alien registration document if the person is unlawfully present in the United States, close quote. This creates a state crime as opposed to a civil violation when none exists in federal law for unlawful presence. Section 18 requires any person stopped by police for driving without a license to be taken directly to a magistrate, and requires that those people determined to be illegal immigrants must be detained and turned over to federal immigration authorities. Section 27 bars Alabama courts from enforcing any contract involving an unauthorized immigrant. That is, home rentals, car loans, mortgages, telephone contracts, etc. Section 30 makes it a felony for an illegal alien to enter into a business transaction with the state of Alabama. Makes it a felony. For example, in some cases, applying to receive water and sewage in your home. I'm going through this because I think people are not aware of what this law says, actually. And then section 28, and I'll read it in its entirety, or this is not the whole thing, but this is the core of it. Quote, requires every public elementary and secondary school in Alabama to determine if an enrolling student was born outside the jurisdiction of the United States and is the child of an unlawfully present alien and qualifies for assignment to an English as a second language class or other remedial program, close quote. Now, to give you a sense of the difference between journalism and scholarship, we deal in things that are happening recently, and as it happens, as I was coming down here on the train this afternoon, at about 3 o'clock in the afternoon, the appeals court for the 11th Circuit stayed 2 of these provisions that I've read to you. They stayed, this is pending appeal. The Justice Department appealed the ruling by Judge Blackburn, and the appeals court has stayed this section 28 having to do with schools, and also the section that requires, section 10 requiring individuals to carry documents. And so this afternoon, pending the process of the consideration of the appeal, those 2 provisions have been held up, but the rest that I read today is going forward in Alabama. Taken together, these provisions constitute a comprehensive attack on every aspect of the lives of illegal immigrants in Alabama. Under this law, a person without legal status cannot turn on the tap for water in some places, cannot buy or rent a home or a vehicle, cannot risk driving at all, and cannot confidently send their children to school. In addition, the law sets up countless situations, generally unregulated, where people perceived to be immigrants can be required to show status documents. Little wonder that thousands of immigrant families decided last week to leave the state immediately rather than wait around for the judicial appeal. Nor is this impact accidental. And I'm quoting, "This is a jobs creation bill for Americans," Representative Mickey Hammond, the Alabama Republican who was a chief sponsor of the bill, told me on the day it was passed. He said, "We really want to prevent illegal immigrants from coming to Alabama and to prevent those who are here from putting down roots." However, it was Judge Blackburn's ruling that really raised Alabama HB 56 to a matter for national scrutiny. I must say, I have the impression that the Justice Department lawyers were complacent in preparing their briefs. They offered only arguments about the primacy of federal immigration law over state law, arguments that, in fact, had persuaded federal judges in other states. None of the civil rights issues raised by the Alabama law were challenged in the federal government suit. There have been other lawsuits, but the federal brief did not raise the civil rights issues. In her decision, Judge Blackburn sided with a dissent in a narrow 2-to-1 decision by a 3-judge panel in the appeals circuit that upheld the Arizona stay. So what Judge Blackburn did is she went into the appeals court decision in the Arizona case, and she looked at the dissent. This was the appeal was decided by a 3-judge panel. It was 2 against 1. There was a dissenting judge, and she embraced the dissent in that case. Her decision articulates and puts into practice an alternative interpretation of federal preemption in immigration law as applied to state enforcement. It represents, in my view, a watershed triumph for an intensely committed group of conservative lawyers led by Chris Kobach of Kansas and Michael Heffman of the legal arm of the Federation for American Immigration Reform, who have been tenaciously battling in the courts for greater state immigration enforcement since their first foray into the field in Hazleton, Pennsylvania 5 years ago. Chris Kobach and Mike Heffman have made clear that their goals for HB 56 are not limited to Alabama. The provisions of HB 56 on school enrollment are a social experiment and a data-gathering exercise conceived with a grand goal: to prepare a challenge before the Supreme Court to a foundational ruling that has framed the lives of illegal immigrants and their families for 3 decades. The 1982 decision in Plyler v. Doe, which found that public schools cannot deny admission to children of unlawfully present immigrants. Already the law has generated a powerful riptide in Alabama schools. Although the state superintendent has insisted that no child will be denied admission, already small children have been singled out for questioning about their immigration status. A reader of AL.com, a news website in Birmingham, reported that her child was one of 2 students in a Birmingham kindergarten class who was asked to fill out a form, to bring a form to her parents that would identify the immigration status of the child and of the parents. In that case, both the mother and the daughter are United States citizens. The mother reported that the school's assistant principal had told her the form was handed out to the children, quote, whom they thought were not from here, close quote. You don't need to be a scholar of child psychology to say discussion of a practical problem that we're experiencing in the United States. My job as a journalist is to inform primarily, and so that's what I'm going to try and do tonight a little bit. We were asked for this panel to consider the impact of current immigration policies on families. The initiative that is having the most immediate, more important than ever now on this particular debate to be constantly working to try and bring it back down to earth and back down to I'm very glad to be here. The debate over immigration has, in recent years, since I've been covering it, come substantially unmoored from practical discussion of a practical problem. And so the engagement of scholars and researchers, I think, is